Hello everyone, this is Professor Al Mary, your instructor in Political Science 2030. And this week, today, we will be covering the federal courts. That's chapter 13. First, I want to review the objectives set forth in that chapter by the authors of the textbook. They have 4 objectives. They aim to explain to you the power of judicial review, namely the power of courts to decide whether an act of the legislature or the president is constitutional or not constitutional. It's a very controversial question because the Constitution creates creates co-equal branches of government, and so the power of judicial review means the courts can tell the president or Congress if they're doing something right or wrong by the Constitution. Second, they aim to outline the structure of the judicial system for you, the federal judicial system, the trial and appellate structure of the federal courts. Then they try to chart out for you how cases reach the Supreme Court and the Supreme Court process, exactly what it takes to get a case heard in the United States Supreme Court, and then examine some of the facts that influence Supreme Court decisions, external factors as well as other factors. Note that Chapter 12, bureaucracy, we will cover that next week. I wanted to create structure flow between the 3 branches of government, since we also cover the California state government as well. So we've covered so far Congress, the legislative branch, the presidency, and now the courts. And so these 3 branches, institutions of national government, I thought would go together. Now let me outline the objectives of the supplemental lecture here. Again, this is on the federal courts. There will be a separate lecture on California state courts to follow. Here I aim to examine the adversarial system, the unique system that the United States has, in which adversaries or 2 contesting parties present their facts before an impartial fact finder or judge, and a decision is made based on what the 2 sides present, subject to certain kinds of rules about the introduction of evidence and so forth. And then we'll distinguish between types of legal cases, criminal and civil cases, and what each type of case involves. And then the structure and process of federal courts and the administration of the federal courts. This is a picture of the United States Supreme Court building in Washington, D.C. That is, in effect, the very symbol of the 3rd branch of government, just as the White House symbolically represents the presidency and Congress and the Capitol building, Congress. So this building represents the Supreme Court of the United States, or the judicial power of the United States symbolically. Now let's do a brief historical overview so you get a sense of what the Supreme Court is all about. As you will recall from our study of the Constitution creates the 3rd branch of government in the Supreme Court. In other words, by creating the Supreme Court, the institution of the Supreme Court, the Constitution created and vested that judicial power, the power to adjudicate cases, to interpret the Constitution and apply it, to interpret the laws of Congress. So that's the function of the 3rd branch of government, the judicial branch. Interestingly, the Constitution created a single entity known as Supreme Court and left the rest of the lower federal courts to the discretion of Congress. In other words, the Supreme Court is the creation of the Constitution, but the other courts, the federal district courts, the appellate courts, and other Article 1 courts, are actually creatures of Congress itself. The federal judiciary was created, that is, other than the Supreme Court, which is created in the Constitution, very different from what Congress can do, in the Judiciary Act of 1789, and in that act, Congress divided the country into 13 judicial districts, and all of them, of course, subject to the highest judicial authority, which is the Supreme Court. And in the Judiciary Act of 1789, the Congress did a bunch of other things also, which in fact led to the question of judicial review discussed in the textbook, particularly Section 13 of the Judiciary Act, which gave the Supreme Court original jurisdiction in cases involving writs of mandamus. That is discussed in the textbook. Initially, the Supreme Court had a Chief Justice and 5 Associate Justices. Today, of course, we have a Chief Justice and 8 Associate Justices. For the first 100 or so years, the Supreme Court also conducted what's called riding the circuit. In other words, they would go into these 13 judicial districts and hear cases. Of course, they don't do that anymore. In fact, Supreme Court justices today, not only do they not ride circuits, they also selectively accept cases, which we'll see later on, by a process called petition for certiorari. The Supreme Court first assembled on February 1, 1790, in the Merchants Exchange Building in New York City, which was then, of course, New York City, the nation's capital. The first cases reached the Supreme Court in 1791, and the first case that was handed down, first opinion by the Supreme Court, was on August 3rd, 1791, in a case called West versus Barnes. The Supreme Court also has rendered some of the most significant decisions in American history, including Marbury versus Madison, which is discussed in the textbook, dealing with the power of judicial review. The Supreme Court has made numerous decisions that have changed the history of the United States in very significant ways, from issues concerning slavery to political rights, First Amendment rights, rights to religious liberties, and also the rights of criminal defendants. Now let's look at the Supreme Court itself. Supreme Court is established in Article 3. That's important to remember because Article 3 defines the judicial power of the United States. And as indicated earlier, all other federal courts are created by Congress. Now, these courts that are created by Congress are sometimes also referred to as Article 3 courts, which include the United States District Courts as well as the U.S. Courts of Appeal, but also what are called legislative courts, non-Article 3 courts, which we shall see later. And these would be courts that do not have the same, that are not appointed under the same terms and conditions under Article 3. The Article 3 basically states that the judicial power of the United States shall be vested in one Supreme Court, one single Supreme Court, and inferior courts, as the Congress may from time to time ordain and establish. So, again, to underscore the point, Supreme Court is created in the Constitution, and all other courts are created by Congress. Now, the Supreme Court has final authority in cases involving the Constitution, acts of Congress, or treaties. In other words, when it comes to interpreting the Constitution, which is the subject matter of judicial review, and acts of Congress, laws passed by Congress, or treaties, if there are any disputes with respect to these 3 areas of law, then what the Supreme Court says is the final word. Of course, that does not mean that an act of Congress cannot be changed by Congress and then made to accommodate a decision of the court. But the test, of course, is that the Supreme Court has the ultimate authority in interpreting and applying the Constitution. So any act of Congress or treaty that is inconsistent with the Constitution will be struck down as unconstitutional. The Supreme Court has cases can be heard and decided by the Supreme Court in something called original and appellate jurisdiction. In other words, the courts do, unlike Congress, do not consider anything that comes before them. They consider only things that they are allowed either by the Constitution or by an act of Congress to hear and decide. And so the whole idea of jurisdiction means the power of the court to hear and decide a case. So the Supreme Court can hear and decide a case either as an original court of jurisdiction or as an appellate jurisdiction. And when it sits as a court of original jurisdiction, that means the Supreme Court sits as a trial court. That doesn't happen very much. There are a very limited set of circumstances set forth in the Constitution where the Supreme Court has to sit as a court of original jurisdiction, oftentimes involving legal disputes between states, foreign consuls and ministers and things of that sort. But those kinds of cases rarely arise, and when they do, the Supreme Court has other procedures by which to deal with them. So in almost all cases, the jurisdiction of the Supreme Court is appellate, which means that the case has been decided below, and someone is dissatisfied with the outcome, and they seek to have that lower court decision reviewed by the Supreme Court. And there are some complicated procedures because Supreme Court does not hear appeals as of right, which means just because you wanted to appeal the Supreme Court, you cannot force them to hear it. They have to exercise their own discretion, and we'll talk a little bit about that later. So the vast majority of cases come to the Supreme Court by way of an appeal or by a petition for certiorari. Today there are 9 justices on the Supreme Court and 1 Chief Justice. And the vast majority of cases are actually resolved at the Court of Appeals level, which means that I would say 99% of all federal appeals cases are resolved in the 13 federal appeals courts. Now let's look at jurisdiction. As I said, there are 2 types of jurisdiction mentioned in Article 3. The first one is original jurisdiction, and that is the power of the court to hear and decide a case on first instance as a trial court. They hear the evidence, they hear the witnesses, they examine the evidence and so on, and they make a decision. In other words, original means the court originates there or begins there, and it adjudicates facts. It determines, if it's a criminal case, determines whether the accused is guilty or not guilty. If it's a civil case, they determine which side has made the prevailing case based on certain kinds of evidentiary standards. In criminal cases, that would be guilt beyond a reasonable doubt, a very high standard. In civil cases, it could be less than that. Could be by the preponderance of the evidence or by clear and convincing evidence. These are technical kinds of rules by which the trial court makes a determination as to whether or not something is factually proven. In an appellate jurisdiction, the jurisdiction basically is to hear cases that are brought to them on appeal from decisions of a lower court. They do not deal with factual issues. They don't call in, there's no jury there are no witnesses called, there's no development of additional factual record. All they do is look at the record, usually the written transcript of what happened at the trial, and they try to determine whether there's been a legal error or other kinds of error which require that the decision or the judgment of the lower court be modified or changed or even reversed. So the appellate jurisdiction is basically a review court which determines whether or not there's been a mistake committed and whether that mistake is of such magnitude that it affects the right of due process of the parties making the appeal. Now, the United States is very unique in the sense that we have what's called an adversarial system. The adversarial system basically relies on the 2 sides bringing the case before the court. The idea is that when you have 2 sides contesting before an impartial tribunal, an impartial judge or jury, then the truth will emerge in the struggle between the 2 parties who try to bring out as much evidence, as much truth, so to speak, to convince the fact finder that their side is the truth. So the idea is that the 2 parties, the plaintiff and the defendant, will present their facts, they'll make their arguments and so on, and try to convince the judge or the jury that their position is the correct one. Now, this is not the kind of system that's practiced throughout the world. In most countries, the vast majority of countries, they have what's called an inquisitorial system in which the judge also participates in the fact finding. But here, the role of the judge in the adversarial system is simply to preside and make sure that nobody plays the game unfairly, to make sure that the rules of evidence are applied, and beyond that, to make sure that the jury conducts its fact finding by the terms and conditions given by the court. So it's adversarial in the sense that the two parties will present their facts and their evidence, but it also means that it is an orderly process by which the evidence is admitted based on rules of evidence and other rules of court, and the outcome is fair. Because the ultimate aim is to provide due process, that both parties, whether it's in a criminal case the state and the accused, or in civil cases the two parties get due process of law. Now, the United States judicial system can be conceived of at the federal and state level. We have at the federal level the Article 3 courts, created in the U.S. Constitution, and then the other courts created by Congress, and of course the 50 states have their own courts, and those state courts are governed by state constitution and state laws. But both the federal and state courts are independent in and of themselves, meaning that they cannot be subjected to political pressure by anyone else, either the legislature or private individuals. Although federal judges hold their term of office for life and as long as they are conducting their business in good behavior, state court judges are oftentimes elected. Very few states, in fact, I know of no state courts that have life tenure. Now, it's very important to keep in mind that most of the U.S. law is administered at the state level. In other words, the kinds of cases that end up in federal courts are very, very few, because the vast majority of criminal and civil cases take place in state courts, over 90% of them. And so it is important to keep in mind that the federal courts play a significantly diminished role in the administration of justice in the United States, because their jurisdiction, the kinds of cases that they can hear and decide, are limited by the jurisdiction granted in the Constitution and by Congress. And we know from the Constitution that federal courts can deal with issues related to the U.S. Constitution, laws passed by Congress, and treaties. And beyond that, they really don't have any power to hear and decide cases, especially cases arising under state law and state constitutions, unless, of course, those laws and state constitutional provisions violate some aspect of federal law or the U.S. Constitution. Now, let's look at types of cases that come through the U.S. judicial system, both at the state and federal system. Oftentimes, or the vast majority of cases, are either criminal or civil. And criminal cases are the types of cases in which the government, not private party, but the government accuses a person of having violated some criminal law. They may have committed a murder, bank robbery, or some wire fraud, whatever it is that the state or the federal government has legislated as being a crime. When a person violates that rule or that law, then a criminal case is instituted against that person. And the ultimate outcome of a criminal case, of course, other than an acquittal, is that the person convicted of a criminal case loses his or her life, liberty, or property. So in a criminal case, the plaintiff is always the government, and it's called the prosecution. In a federal case, called the U.S. attorney. In state cases, it could be the district attorney or the U.S. attorney. And the person accused of committing or violating the law, the criminal law, is called a defendant. Now, in civil cases, civil cases are different because the complaint in a court is asking to resolve a dispute that does not involve criminal penalty. Oftentimes, in a civil case, the dispute involves money or personal injury or land or some other aspect of law or rights in which the outcome is not criminal penalty, unless, of course, the civil case is transmuted in some kind of a criminal case. So ultimately, in a civil case, damages are calculated in terms of monetary compensation. And in civil cases, the person bringing the civil case, so if you get injured in a car accident and you sue the person who caused that accident, you become the plaintiff, and the person who caused the accident is called a defendant, in much the same way as a criminal case. But of course, the outcome is different. When that case is appealed, the plaintiff then becomes petitioner, and then the defendant becomes respondent. And so there are different kinds of names, but these are just labels to signify who is bringing the action and who's defending against the action. Now, before any lawsuit is filed, particularly in a civil case, but also in a criminal case, one has to have something called standing. Standing is a legal concept, which means that the person injured, in this case the plaintiff, has a serious interest in the dispute, or the plaintiff has suffered or likely to suffer a direct and substantial injury that can be addressed in the case. So if you were injured in a car accident, or if you have a contract and the other party breached that contract, then you have a dispute on which you can establish standing, meaning that you've been injured and now you can go to court and try to seek redress for that injury. In the criminal case, oftentimes that's not much of a problem, because the prosecution, and only the prosecution, meaning that the government is the only entity that can bring a criminal case, and their standing, of course, is that they're enforcing the criminal law. And in some technical instances, it could be challenged that the government may not have a standing to bring a lawsuit, but those kinds of issues rarely occur. Now, in terms of standing and in terms of bringing a lawsuit, in federal court, the first level, in other words, the first place that a person can access the federal courts and file a lawsuit is in the U.S. District Court, and that is the lowest court in the federal system. You have the Supreme Court at the top, and you have the U.S. Courts of Appeal, Court of Appeals at the second level, and then at the bottom level is the U.S. District Court. Again, all of these are Article III courts, and they're appointed by the President and confirmed by the Senate. And the U.S. District Courts are the general trial courts of the federal court system. That's where you bring in your case. If it's a civil case, that's where you file to seek redress for whatever money damages you may have suffered in a civil action. And if it's a criminal court, that's where you'll be sued in violation of the criminal law. So what it means by trial court is you try the facts. You bring out the facts before the judge or jury. You call in your witnesses. You bring in expert witnesses. Anything that aids the determination of the facts. So in a criminal case, the outcome is going to be whether the defendant is guilty or not guilty. In a civil case, whether the plaintiff has proved her case based on certain evidentiary standards, and a judgment is made. And so if there's an acquittal, the person is freed, and they go home. If you win your case in the U.S. District Court, you gain your money damages, and that's the end of it in terms of that. Of course, the second level is for appeals. Now, each U.S. District Court has at least one United States District Court appointed by the President, confirmed by the U.S. Senate. So, for instance, California has 4 U.S. District Courts, which means we have because the state is very large and the caseload is very large. You have the Central District, which includes Los Angeles. You have the Eastern District, Up in Sacramento, you have the Southern District in San Diego, Northern District in San Francisco, and so on. So the state is divided into different U.S. District Court jurisdictions. These district courts handle both civil and criminal cases, as I said, and they're also the same districts for the U.S. attorneys. Those are the primary prosecutors for the federal government. And the district court judges are also responsible for managing the court and supervising the court employees. And like all Article 3 judges, they serve as long as they maintain good behavior, and they can only be impeached and removed by Congress. So they are just like the president, subject. Well, they have a lifetime tenure, unlike the president, but their tenure is subject to good behavior, which means unless they're accepting bribes or committing other kinds of crimes, they're in it for life, just like other federal judges. There are now over 670 district court judges nationwide, so you can imagine 670 judges. If you look at the U.S. population of about 320 million, that's not a lot of judges at all, but also shows you how limited federal jurisdiction, court jurisdiction is in terms of the kinds of things that they do. The vast majority of cases are decided at the state level. Now, aiding the U.S. district courts, as I said, there are only 670. Imagine the 300,000+ cases that are coming, that are being filed in the U.S. courts every year. The 670 judges cannot handle all those, so they appoint what are called magistrates. And these magistrates are appointed by a majority vote of the federal district court judges in a particular district, and they serve for a term of 8 years if they're full-time, or 4 years if they are half-time. And they do a lot of the groundwork, as it were, the grunt work for U.S. district courts, the kinds of routine things that U.S. district court judges may be required to do. And essentially, they take off a big load from the Article 3 judges. For instance, in criminal matters, issuing search and arrest warrants, conducting initial preliminary hearings, setting bail, things of that sort, deciding motions. All of that stuff is done by a magistrate courts, by and large. Just imagine if U.S. District Court judges had to do that. They would practically have no time to do anything else because of the number of criminal cases that are filed and the kinds of pretrial activities that must take place. So the magistrates do a whole lot of that work. In civil cases, magistrates also do a lot of the pretrial stuff, which is mostly pretrial motions and discovery. So in civil cases, a lot of the work is done before you get to trial, which means you have to do discovery, you have to get facts, evidence, information from each other, and so on. Sometimes the parties will resist that, and so the magistrates will decide if it's discoverable, meaning that the material that's being requested is not protected by some kind of privilege. Which means that it doesn't involve something that let's say so private or a matter that is proprietary that the party does not have to yield and so forth. But generally speaking, in civil cases, information held by the other side is discoverable. That means it should be presented to the other side. So when they get to trial, there will be no trickery, no hiding the ball, as it were. Everything comes out, and a decision is made based on the facts. So these are the kinds of things, very important things that the magistrates do. But for the magistrates, U.S. district court judges will simply be swamped. Let's look at the pathway to a case heading to the U.S. Supreme Court. As you can see, very straightforward. At the top in red, you see the federal district courts. If a party loses at the federal district court, they can appeal to the U.S. to the U.S. Circuit Court of Appeals, and then from there to the U.S. Supreme Court. As you can see, about 65% of the cases are appealed to the U.S. Supreme Court, to the U.S. Circuit Court of Appeals. very little of original jurisdiction, as we discussed earlier. The Supreme Court doesn't sit as a trial court at all, very rarely. And then from the state also, from the state trial court through the intermediate state appellate courts, and then up to the Supreme Court. Again, we'll look at the state court process in greater detail. Just simply, this chart shows the pathway to a case navigating to the Supreme Court. But what the Supreme Court actually decides is a very tiny fraction of all cases that it chooses to decide, not as of right, but because the Supreme Court itself chooses to hear those cases. Now, if we look at the case distribution, 98% of all cases are decided in state courts, which is a tremendous amount. And of those, only a small percentage of them are decided by trial. Most criminal cases are decided by plea agreement. Most civil cases are decided in settlement between the parties. So only a very tiny percentage of cases go to trial. And the reason for that is there are many, but one of them is that in a criminal case, the defendant, especially if the evidence doesn't look too terribly favorable to them, they would make a plea agreement, because in the plea, the U.S. attorney will provide lesser time for a plea agreement. That means you don't have to go to trial, you don't have to go through all the trouble and so forth. But and the advantage is that the defendant knows that if he goes, she goes to trial and gets convicted, the likelihood that they will get more time is significantly higher. So, in most cases where the evidence does not look too favorable for the defendant, it's settled by a plea agreement. That's why most criminal cases are plea bargain, and the same with civil cases, because the outcome is always uncertain. You go to trial, it could be an all or nothing. So if either party, if you have a strong case, you may go to trial, but you also cannot be absolutely sure that you can win, and so you will settle the case perhaps for a lesser amount. If the offer is, let's say, $1 million, and you think you can get $2 million. By going to trial, but if you go to trial and lose, you get nothing, so most likely you will decide to settle. So there are different kinds of calculations that go into settlements, but that's how cases are resolved. The U.S. District Court, the Court of Original Jurisdiction, as we said, there are 90 plus U.S. District Courts, at least one in each state. In California, we have 4 of them. And the subject matter of the court's jurisdiction, again, meaning that the kinds of things that they hear and decide are specifically set forth in statute. They can hear and decide cases involving all federal crimes, not state crimes, just federal crimes. And then all civil disputes arising under federal law, because most civil disputes do not arise under federal law, they arise under state law. And even for those kinds of cases, there are additional requirements, jurisdictional requirements, which means that the dispute has to be between citizens of different states, and the amount they claim must be at least $75,000 or more. So there are many bottlenecks in accessing federal courts, at least in civil cases, and of course in federal crimes, only for those crimes that are enacted by Congress. So there are many criminal laws that are also similar at the state level. For instance, bank robbery is a crime at the federal and state level. So although the accused can be prosecuted both at the federal and state levels, oftentimes the U.S. attorneys will allow the states to deal with that issue because the crime is so serious that whatever penalty attaches is probably as grave as it's going to be. So there are some areas of federal criminal jurisdiction as there are civil jurisdiction, but the vast majority of them are under state law. Now let's look at the courts of appeal. As I said earlier, the jurisdiction of the courts of appeal, United States Courts of Appeal, is basically to review the final decisions of the district courts and other regulatory agencies, but we're not going to get into that one. But within a particular geographical area. So there 13 appellate districts. We will see the distribution in the next slide. And so, for instance, in California, all trial court appeals from the western part of the United States, basically, we'll see the map later, but about 5 or 6 states, it goes to the Ninth Circuit Court of Appeals. So they're all organized geographically. And the singular purpose of the Courts of Appeal is to review the decisions of the district courts, or it could be administrative agencies, and determine whether or not there has been legal error made. In a criminal case, they determine if the rights of the defendant have been violated. For instance, if the person was not given his right against self-incrimination, his Miranda rights, and that evidence was used in court, well, that is potentially a violation of the individual's right against self-incrimination. The court could say, yeah, that is that evidence should not have been introduced, and because it was, the person was denied due process, and the court can reverse that. That was the legal error that they corrected. So these are kinds of issues that they would review. Legal errors, errors of due process, and things like that. There are 94 judicial districts organized into 12 circuits, each responsible for a geographical region with one federal circuit. In the Court of Appeals, the judges hear cases, also in specialized cases involving patents, claims, international trade, and so forth. Each circuit court has between 8 and 29 judges, depending upon how large the district is. And usually appellate courts sit in panels of 3 judges and issue opinions. Only rarely do they sit en banc, which means en banc means they all 12 of them will sit and decide a case if it's extremely important or raise an issue of a new issue of significance. And here are the 13 federal judicial circuits. As you can see, in the sort of orange to the left, that's the Ninth Circuit, and that includes California, Nevada, Idaho, Arizona, Montana, Washington, Oregon, and Arkansas, and Hawaii. So you can see the rest simply by matching the color-coded numbers with the various states. So district courts in these areas and administrative decisions affecting these areas are appealed to the particular Court of Appeals. And so just a chart here to give you a quick contrast between federal courts and California courts. In terms of jurisdiction, federal courts are of limited jurisdiction, I said. They're limited to matters involving the U.S. Constitution and U.S. laws passed by Congress, U.S. treaties, bankruptcies, patent, admiralty, international. These are the kinds of issues, subject matter that they can decide. Nothing else. They cannot get involved in, let's say, personal injury cases and so forth, unless it involves some technical issues of federal law. And the kind of people who can sue are the federal government, or it could be state governments, could be ambassadors and public officials, or even foreign states that they can access the federal courts. And if they're civilians, they must meet what's called diversity jurisdiction, meaning that if they are citizens of different states and they meet their requirements, then they can file in federal courts. So it's very limited jurisdiction. That's why you don't see too many cases there. In California courts, of course, the jurisdiction covers a lot of things. We will see later in the second supplemental lecture. But any issues involving business contracts, domestic relations, family law, personal injury, state criminal offenses, state constitutional claims, and even some federal constitutional claims prosecuted in state tribunals. For instance, in a state case, a criminal case, a defendant alleging that his or her right against self-incrimination under the federal constitution have been violated, and so the state court can also adjudicate that. And here's the structure of the federal court. As you see, at the very top is the United States Supreme Court with 9 justices, and as you can see, petitions that are filed. That includes petitions from the courts of appeal, petitions from some petitions from the district courts, administrative courts, or whatever, and improper petitions from prisoners and so on is over 11,000 a year. And the Supreme Court gives full review in less than 100 cases. That means they will review the case and issue a written opinion. So you can see the probability of getting your case to the Supreme Court in any given year is almost next to nothing. And that's because the court exercises what's called discretionary review by granting petitions. Again, not a right of appeal, but a petition to have your case reviewed. So we have 179 judges, as you said, 670 judges in the district court, and only 175 judges in 13 circuits. So you can see we don't have that many courts of appeal judges, and they handle over 50,000 appeals. Now, there are also a class of federal courts known as Article 1 courts, because they're created not under Article 3, which is what the U.S. district courts are, excuse me, but under Article 1, called legislative courts, because they're created by the legislature, by Congress. Article 3 courts are created by the Constitution. Only Congress, under authority of Article 3, creates the lower courts. But these courts, Article 1 courts, legislative courts, are created purely by Congress, and they include the International Court of International Trade, Court of Federal Claims, Federal Bankruptcy Courts, Courts of Appeal for Armed Forces, Veterans Claims Courts, and Tax Courts. So these courts deal with specialized areas of the law. So in bankruptcy, deal with bankruptcy issues, and Court of Appeals for Armed Forces, and those are decisions of the military courts, and they're given, they're treated differently. So because they involve specialized kinds of legal issues, Congress has decided to create special courts. They just, for instance, tax court involves the tax law, which is very complicated and complex, and so there are judges who specialize in those kinds of things. That's basically what the Article 1 courts do. So you need to know the distinction between Article 1 courts and Article 3 courts. Again, a chart here in terms of in terms of the United States Supreme Court review powers and how it exercises its discretionary powers. So you can see from the district courts, it goes through the U.S. Courts of Appeal, 3 judge panels. Again, only questions of law, the same way with the trial courts. And the distinction being that if the state Supreme Court decisions involve federal questions, some aspect of the Constitution or some aspect of federal courts, it could be reviewed by the U.S. Supreme Court. However, if the issue on the state side here, to your right, deals with a question of state constitutional law or interpretation of state law under the state constitution, it terminates at the level of the state Supreme Court. In other words, the United States Supreme Court does not review an issue of a state constitutional law, unless, of course, that state constitutional law infringes on federal constitutional law. But that's the sort of structure process. Now let's talk a little bit about the legal profession, and this is just generally speaking. You have to have an undergraduate degree, at least 4 years. Could be in any field. Most students applying to law school either major in political science, history, or English, or something along that line. Law school is a 3-year process, and during the first year in most law schools, the courses are pretty much established for the first year and a half, or at least the first 3 semesters. And usually these courses involve civil procedure, constitutional law, criminal law, evidence, property, torts, and legal writing. It could vary from school to school, but these are kind of the core courses that every student who enrolls in law school must take. Then you in the second half of your legal education, you can take electives like commercial law, intellectual property law, international law, and a whole bunch of other things. Once a person completes their legal education, they in order for them to practice, they have to take what's called the bar exam, and that's an examination sponsored by the state bar, and usually it consists of a written portion and a multiple choice question called the multi-state. And to take the bar, oftentimes there are different rules, but oftentimes you have to graduate from an accredited law school. But there are also ways that you can take the bar exam without going to an accredited law school, as in California, but they're more the exception to the rule. And in the United States, there are almost 200 accredited law schools. And once you take the exam, and you pass that exam, then you are ready to practice law in the particular sector. Generally speaking, the practice could be in the private sector, maybe as a member of a law firm or represent a corporation, or go solo on one's own. Or one can practice in the public sector, become a district attorney or a U.S. attorney, or work for the government, or work for the courts in some capacity. For judicial office, there is no eligibility requirement as such. So there is no exam that one has to take. If it's for a federal court, oftentimes, almost exclusively, the president appoints, nominates an individual, usually someone either who served in the federal court system, or in the law firms, or from the U.S. Attorney's Office, and that person is nominated, and once approved, confirmed by the Senate, that person becomes a federal judge, and subject to the requirements under Article 3, that would be a life tenure, subject to good behavior. They do get training, but it's not mandatory. No mandatory prejudicial training, so you don't have to go to judge school to become a federal judge. But they do have voluntary continuing judicial education. But generally, in the state system, in most places, I believe, including in California, you find that there is some prejudicial training and mandatory judicial education, which is also required for lawyers as well. Every 3 years, they have to take a certain number of credits, sort of updating themselves in different areas of the law. Judicial selection for Article 3 judges, they're nominated by the President and confirmed by the Senate. Now, the recommendations for these nominees could come from legislators, others from senators, or the President's advisors, and perhaps even the American Bar Association. Usually an investigation is conducted, background check to determine if there are any issues that will disqualify the person from being fit to serve as a federal judge, and once that investigation is completed, it is submitted to the Senate for review. Oftentimes, the American Bar Association also rates the candidate as for fitness, judicial office, and that recommendation is also made. And then a Judiciary Committee hearing is done, as was done with Associate Justice Barrett a few weeks ago. And then the Senate will vote, and what is required is 51 votes in favor, and the person is confirmed as a federal judge. Now, with the other non-Article 3 or Article 1 judges, bankruptcy judges, which oversee basically bankruptcy cases and so on, they're appointed by courts of appeals to renewable 14-year terms. Magistrates are appointed by district court judges, as I said, renewable 8-year terms. and federal claims are appointed by the President with Senate confirmation to renewal 15-year terms. Now, in the federal courts, we have sort of a hierarchy here. You have the Chief Justice of the United States, of course, Roberts, nominated by the President, confirmed by the Senate, and the duties of the Chief Justice include presiding over court sessions, over the Judicial Conference, and other kinds of institutions. So basically, the Chief Justice is kind of the head of the Supreme Court, and also manages the court's affairs, as it were. In the Courts of Appeal, you have the Chief Judge, basically normally assigned by seniority, the person who's been there on the longest period, and as a Chief Judge serves for 7-year terms and supervise court administration, including clerks of court and so forth. You may also have a senior judge. Eligibility is over 65 years. And the senior judge may serve until the age of 80 with a reduced caseload. So oftentimes they've gone into retirement. Now let's talk a little bit about the nature of the federal courts. Diversity is one of the biggest issues in the federal courts, as it's perhaps in the legal profession in general. And as you can see here, that only 25% of the federal courts are female, which means the vast majority are male. If you look at the distribution by race, again, you can see Caucasian is 81%, African American 11%, Hispanic 7%, and Asian American 1%. So there's a great need for diversity in the federal courts, both in terms of race, ethnicity, and gender. Looking at court personnel, at the Court of Appeals, you have the Chief Judge and 12 other appellate judges with central staff. Court staff, about 69, staff attorneys of maybe 27. Each judge staff includes law clerks of 3 individuals with secretaries, and the law clerks basically do all of the grunt work. They do the research, they do the drafting of the opinions and things of that sort. Otherwise, each individual judge would not be able to handle that. So these law clerks, usually recent graduates from law schools with good legal writing skills, often aid the judges in drafting opinions and doing legal research and other things as well. At the district court level, again, you have the chief judge plus 6 district court judges with a central staff, and each judge's staff with 2 law clerks, and the same with bankruptcy court judges. Now, federal court federal judicial administration, as you can see at the very top, is the Chief Justice of the Supreme Court with the administrative office and the judicial conference that we mentioned in the previous slide. And so through the Chief Justice, you see the circuit Chief Justices and the circuit judicial councils right down to the district court. But also on the left side, you see here the Federal Judicial Center, and by itself, the Sentencing Commission does not come under the Chief Justice. So this is more or less the structure of federal judicial administration. Financing of the federal courts, at least as of 2018, it's a very expensive operation. 7.2 billion is what it took, at least as of 2018. And 96% of it is for Court of Appeals, district courts, and other judicial services. 4% goes to the Supreme Court and the federal circuits and others. And you can see here the federal, the judicial salaries. It should be actually 2016 instead of 2006. Supreme Court salary is now about $277,000 a year. The Court of Appeals at around $265,000, and U.S. District Courts $208,000. bankruptcy and magistrate judges at around 160. So for the kind of work that they do, it's not a lot of money, because in private practice they could probably make 3, 4, 5 times as much. And so when they become federal court judges, they're not doing it for the money, the vast majority of them. They're doing it because they want to provide public service, and of course also for the prestige comes with federal bench. Judicial conduct and discipline, of course, from time to time there may be problems on the federal court. Could be problems with ethical issues. It could be issues involving misbehavior, misconduct in terms of duties and obligations. And so the judicial branch has its own rules of conduct, and it reviews complaints against judges and determines sanctions in most instances, including and up to impeachment. Also, the legislative Congress sets rules on outside income, recusals, and gifts. And ultimately, of course, if a judge commits an impeachable offense, it will go to the Senate for final determination. The Constitution, under Article 3, states that judges shall serve during good behavior, which means that's not specifically defined, but they cannot engage in unethical behavior, they cannot take bribes, they cannot commit crimes and things of that sort. But reinforcing the Article 3 provisions are various statutes which regulate judicial conduct, including Judicial Conduct and Disability Act of 1980, financial disclosures, limitations on income, and disqualification. So all of these kinds of actions are codified, and there is also a code of conduct that judges must conform to, called the canons, judicial canons, created by the Judicial Conference, and these are the do's and don'ts of for judges. If there is, under the Judicial Conduct and Disability Act, there's a procedure set for processing complaints against federal judges, and so allegations could include conflict of interest and bias, undue decisional delay, medical disability, all sorts of things. So even the judges have a due process in the way that action can be, disciplinary action can be taken against them. A 2006 study showed that there's been really no serious problem with the judiciary's handling of the vast bulk of complaints, but found the handling of 5 highly visible cases problematic. In other words, the vast majority of cases brought against judges do not have much merit, and that's because federal judges are very careful in the way they discharge the obligations of their office. Again, this chart shows the process from the time the complaint is filed. It goes to the Chief Circuit Judge, then to the Judicial Council, the Judicial Conference, and possible actions there could be to dismiss the complaint, temporary halt assignments, request retirement or censure, reprimand, or in severe cases, impeachment. U.S. judicial practice. Again, we've covered some of this. Generally, we have common law, which is basically law derived from customs and judicial precedent rather than statutes passed by the legislature. We see that in terms of opinions issued by the federal courts, including the Supreme Court. Those are the precedents. These are judge-made laws, so to speak. The judges actually do not make law, only the legislature can, but at least in terms of the decisions that they've made, those decisions now serve as precedent for future cases. So if similar fact patterns arise, then you can go back and refer to an older case and say, because this case was decided in this particular way and this new case is similar to the old case, it should be decided in the same process. We talked a little bit about the adversarial system and adversarial court proceedings. Let's look at the path of a criminal case. Usually starts with an indictment or information. In other words, there's an accusation made against the individual, and that individual is served with the indictment, usually by a grand jury or a complaint from the U.S. Attorney's Office. And there are three important pre-trial phases. Before you go to trial, certain things happen. There's an arraignment, usually before a magistrate, where the individual, the accused, will plead guilty or not guilty. And then additional investigation is made to gather evidence. And usually plea bargaining takes place before trial, whether or not the person wants to go to trial or to bargain down the charges and avoid a trial and likely more severe consequences. And if the person, again, in the vast majority of cases, probably 95%, 97% of all cases are settled, criminal cases are settled at the plea bargaining stage. And the remainder will end up in trial, and it could be a jury trial or a judge trial. A judge trial means just one judge will make a determination. Jury trial means there are 12 citizens who will decide the case, the facts of the case. And that involves a number of processes, including jury selection. You have to select a jury that is impartial, that will not be influenced one way or the other for the government or the accused. Then the lawyers will make their opening statements. Following that, presentation of evidence. Usually the government, the U.S. attorney, will go first and present their evidence because they have the burden of proving whether the person has committed the crime. And then the defense will present their case. And in the process, evidentiary rulings will be made whether some evidence can be admitted or not. That will be done outside the presence of the jury. At the end, closing arguments are made by both sides, and the judge will give jury instructions, basically instructing the jurors on how to decide the case, how to consider the facts, and what standard of evidence it should use. For instance, in a criminal case, that would be guilt beyond a reasonable doubt, and then the jury will deliberate and render a verdict, which could be guilty or not guilty. If it's guilty, then the accused, then the defendant would have been convicted, and sentencing will take place, and from that, appeal can be taken. In a civil case, it usually starts with the pleadings. A civil complaint is filed alleging a breach of contract or personal injury or whatever the case may be. Make some factual allegations, and once that is filed, then within a certain number of days, usually within about 30 days or so, pretrial conference takes place. Once the person has been served, go before a judge and inform the judge the status of the case, basically where the person has been served. And then from then on, discovery takes place. What that means is that each side will request information from the other, will request evidence from each other. And they will file different kinds of motions. Oftentimes, one side will refuse to turn over evidence or documents and so on, and then they'll go to court, file motions to compel, and those kinds of issues are reserved at the trial level, at the pre-trial level. And that's also the time where settlement discussions take place, whether or not they want to resolve the case between themselves or to seek some kind of alternative dispute resolution. Maybe they want to do arbitration or mediation or something of that sort. During the pretrial conference, oftentimes the judge would also get involved and try to bring the parties together to settle the case without trial. And so there are many opportunities for resolving the case before going to trial, and that's why the vast majority of civil cases also end up resolved before trial. But once they go to trial, a similar process takes place as in the criminal case. And at the end, of course, judgment is rendered, and the losing side can appeal, and sometimes even the winning side can appeal if they think there is some legal error which could give them a better advantage with an appeal. The Federal Judicial Center, established in 1967, basically has the duty of educating and providing research for the federal courts, and it has a board with the Chief Justice and 7 justices and a director. They have a staff of 125. At least their budget as of 07 was 22 million. And lastly, just a few pictures. This is a picture of the when United States Supreme Court Associate Justice Anthony Kennedy visited our campus, Palm Desert campus, in 2015, and gave a lecture to my constitutional law class. And as you can see, I am standing, looking at the picture to the left of Justice Kennedy. And behind me is our department chair and other members of the faculty at Cal State San Bernardino. And this picture shows us having lunch and having just general discussions. And these were my students who participated in the lecture. It's only a partial picture. There were perhaps about 40 or so students present for that lecture. A very interesting time. It made a lasting impression on our students. And that's the end of it. I went over by 5 minutes. It's now 65 minutes. Thank you for watching. The supplemental lecture on California judiciary will follow. And until next week, stay well and take care.